Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of fast track resolution process. Before that, let us recap what we have discussed in the previous class. In the previous class, we have discussed about Insolvency Bankruptcy Board of India. In that lesson, we have discussed establishment of IBBA, how it was established, and the legal framework relating to establishment of IBBA. Then we have discussed composition of IBBA, then powers and functions of IBBA. So today let us discuss about fast track resolution process. So if you observe the statutory provisions relating to this fast track, section 55 to section 58 of the IBC provides for fast track CERP. So we are also having the regulations, insolvency, the insolvency bankruptcy, fast track resolution process for corporate persons regulations 2017. Then why this fast track resolution process for corporate persons were introduced? The basic purpose of these legislations, these regulations are to facilitate expeditious insolvency resolution for small and simple business entities with lesser complexity and limited assets. So if you observe the general CRP process, it takes minimum of 180 days, which can extend up to 330 days, as we have discussed previously, and which is very complicated in nature, and so many things has to be managed parallelly. Whereas in case of small industries, where they may not have big capital base and they may not have the n number of creditors, so that's why it is not relevant or it is not required for them to follow the detailed procedure, and whereby if they want to exit from the business, we need to facilitate them to exit from the business easily. So that's why IBBA has introduced the concept of fast track resolution process for corporate persons, that is fast track CRP process for the small and simple business entities. So that is the basic objective of fast track resolution process. Now let us discuss what is fast track insolvency resolution process. As per section 2, subsection 1, clause H of the Insolvency and Bankruptcy Board of India, fast track insolvency CRP process, fast track CRP regulations 2017, fast track process is defined as the fast track insolvency resolution process for the persons under chapter 4 of part 2 of the Insolvency Bankruptcy Code. So fact to say, if you observe the definition given under section 2 subsection 1 clause H of the IBC, okay, so it is defining that fast track process means fast track process for the corporate persons under chapter 4. So there is no definition actually, okay, so they are only saying that the process that is followed under chapter 4 of part 2 of IBC, when you are following that process, that is called as fast track CRP process. So what is the basic objective of this fast track? Fast track CRP enables the small and micro firms to efficiently restructure or liquidate by providing a time bound, cost effective and professional method to insolvency resolution. So the basic purpose of this CRP, fast track CRP, is that in case of MSME sectors or MSME companies, okay, it is facilitating them to liquidate in a time bound manner and in a cost effective manner in a professional methodology. Okay, so without following the detailed procedure that is applicable to general corporate sector, we can liquidate the company or we can restructure the company within the time framework, minimum time framework. Okay, so that is the basic purpose of fast track insolvency resolution process. Let us discuss what are the benefits of opting for fast track CRP over regular CRP. Why we need to adopt fast track CRP over the regular CRP. So if you observe fast track CRP, the resolution process can take maximum of 90 days. Possibility is there. NCLT can extend the time limitation by 45 days. So at maximum you can have, or you can close the, or you can complete the CRP process within 135 days compared with the regular CRP process. Okay, compared with the regular CRP process, it will go up to 270 days or 330 days, as the case may be. As we have discussed in the previous classes, it can go up to 270 days or 330 days as the case may be. Whereas in case of fast track CRP, it takes only maximum of 135 days. Then this faster approach lowers the expenses and decrease the company disruption and help to protect the asset value. So if you observe, one of the objective of IBC is that realization of the assets and maximization of the assets. Okay, maximization of asset value is one of the core objective of IBC. So here, if you can complete the CRP process in a speedy manner, this helps us in maximization of assets. So that's why this fast track CRP process will help the small scale industries to restructure the company in a speedy manner, and whereby you can reduce the cost of CRP. Then it is especially useful to the small businesses or those with simpler debt structure, allowing for the more streamlined and quick bankruptcy resolution process. So to whom CRP process is useful, fast track CRP process is useful. This fast track CRP process is useful to smaller business or else any company where the debt structure is very simple. Maybe they are having borrowings from one or two people or one or two persons. Okay, where the debt structure is very simple. In such cases, this fast track CRP is useful. Then by addressing the financial difficulties early on, the fast track CRP promotes faster recovery and business continuity. As already we have discussed, okay, because the process under fast track CRP is very quick. We are going to take minimum time period, that is 90 to 135 days maximum. So it addresses the financial difficulties early on. The fast track CRP promotes faster recovery. Okay, so because we are able to complete within 90 to 135 days, okay, it helps us in faster recovery of the debts, and we can ensure that business is continuous in nature. Then who is eligible for fast track insolvency process under IBC? So if you observe section 55 subsection 2, which provides that corporate debtor with assets and turnover with assets and income below prescribed threshold. So section is silent about threshold. Section is enabling the IBBA to prescribe through regulations. Okay, so we are having the triggering points under the regulations. Okay, so if you observe the section, any corporate debtor with assets and income below prescribed threshold, corporate debtors with specific classes of creditors and debt amounts as notified, other categories of corporate persons as be notified by the central government. Okay, these three categories are eligible for the fast track insolvency resolution process. Okay, now let us see as per the regulations. If you observe, to whom these regulations are applicable, small companies. So there is a definition for small companies under the Companies Act. Okay, so this fast track CRP process is applicable, or else who is eligible, the small companies are eligible for fast track CRP process, and startups excluding the partnership firms, because partnership firm is totally excluded from the part 2. Okay, so there is another part is there, as we have discussed previously. Partnership firms, individuals, they are regulated by other part which is not yet notified. Okay, so startups excluding the partnership firms, okay, they are eligible for fast track CRP process. And unlisted companies with total assets not exceeding 1 crore rupees. Okay, so based on the previous financial year balance sheet, okay, if the total assets does not exceed 1 crore rupees, then in such cases you can go for fast track CRP process. Please remember here, it is only for unlisted companies. Okay, unlisted companies cannot go under the fast track. So NCLT in the case of Sri Infrastructure Finance Limited versus Right Towers Private Limited. Okay, so in this case they have confirmed the eligibility of unlisted company with assets under the 1 crore rupees, whereby they allowed fast track CRP process in the case of Sri Infrastructure Finance Limited. Now application for fast track process, how to make an application. Before that, before discussing how to make an application, let us discuss who can make an application. Okay, so creditor or corporate debtor. So when I am using the word creditor, creditor includes both financial creditor and operational creditor. So as already we have discussed in the previous lesson, section 7, 9, 10, same provisions are applicable here also. financial creditor, operational creditor, and corporate debtor, they may initiate the process. Okay. Then the application must include proof of default. So maybe in the previous classes we have discussed about information utility. So the basic purpose of information utility is to maintain the database. Okay, so you may have some database, you may have some evidences in the information utility. So the proof of default can be from the information utility or any other means. Okay, so as specified by the IBBA. Then evidence to show the eligibility for fast track CRP. So as already we have discussed, who is eligible to apply under the fast track CRP? Okay, so if you observe the previous slide, small companies, startups, unlisted companies where the total assets not exceeding 1 crore rupees. So these three criteria you are supposed to satisfy. Any one of the criteria you are supposed to satisfy. So you may be either small company, or else it can be a startup, or it can be unlisted company where assets value does not exceed 1 crore rupees. So when you are making an application, you should prove that evidence to show that eligibility for fast track CRP. So are you a small company? Are you a startup company or unlisted company having assets value not more than 1 crore rupees? You have to show the eligibility. Okay. Then section 57. So section 57 speaks about the manner of initiation of fast track CRP. So we are having detailed procedures are there under the regulations. So you are expected to follow the procedure under the regulations also. Okay, so this procedure must be followed whenever if you want to initiate the application for the fast track CRP process. Then resolution plan requirements. Okay, whenever you are going for fast track CRP process, the resolution plan must have the details of the resolution applicant and connected persons for the credibility assessment. More or less, these requirements are similar to the regular CRP process. Okay. Then apart from this, even you are expected to follow regulation 37(3) of CRP regulations. Okay. In the previous classes already we have discussed. If you observe the lesson of resolution plan. Okay. So there is a separate lesson is there. We have discussed resolution plan. So in the lesson of resolution plan already we have discussed about the mandatory contents and the contents of resolution plan. Okay, so the contents of resolution plan are prescribed under regulation 37. Okay, so same contents must be there even in case of fast track CRP process. Then apart from this, when fast track CRP process is going on, resolution professional is having certain duties. He is expected to submit all the complaint resolution plans. So when I am using the word complaint, here it means that all the resolution plans which are in compliance with the regulations. Okay, I am not about complaint, I am talking about the compliance. Okay, so the resolution professional is expected to submit all the resolution plans which were in compliance with the regulations. Okay, then submit details and orders, okay, relating to regulation 38. That is, regulation 38 provides that preferential transactions. Okay, so you are expected to submit the preferential transactions, undervalue transactions, extortionate credit transactions, and fraudulent transactions. Okay, so in the subsequent lessons, when you are discussing the liquidation process, there you are going to discuss about the PUEF. Generally it is called as PUEF transactions, preferential transactions, undervalue transactions, extortionate credit transactions, fraudulent transactions. Okay, so the resolution plan shall submit the details relating to these 4 transactions. Okay, then other applicable provisions you are expected to follow. Okay, so other applicable provisions we are having from provisions from chapter 2 CRP process and chapter 7 offences and penalties and part 2 of the IBC. Okay, so as may be applicable, you are expected to follow other applicable provisions also. Okay, in a simple language I can say, though the time limitation is very limit, that is 90 to 135 days only, but more or less if you observe the regulations you will understand that the detailed procedure, okay, so the procedure relating to regular CRP are applicable even in case of fast track CRP. Okay, let us discuss the stages of fast track CRP. So first, initiation process. So as already we have discussed even in the previous classes also, who can initiate the CRP process? Forget about fast track, regularly also. Who can initiate the CRP process? Financial creditor, operational creditor, and corporate debtor. Even in the case of fast track CRP also, financial creditor, operational creditor, or corporate debtor, they can initiate the CRP process, fast track CRP. Then subsequently you have to make an application to the NCLT. Okay, so if NCLT approves, that is admits. Okay, so as already we have discussed, once the application is made, NCLT may accept, may admit the application, or they may reject the application. Okay, so once it is admitted, then IRP will be appointed. Interim resolution professional, IRP will be appointed. Then within 3 days, this IRP is expected to make the public announcement. Okay, so statement requesting creditor to submit the claims. Okay, so in the previous classes we have discussed how to submit the claims also in detail along with the forms. In the previous classes we have discussed. Okay, so statement requesting the creditor to submit the claims will be given. Then once the claims were received by the corporate debtor, okay, then they are going to verify the claims. Okay, submission and verification of claims will be done subsequently. Then after that, okay, you are going to parallelly, these things will happen parallelly. So formation of COC. So once the IRP is appointed, then he is going to form the COC. Okay, then COC is going to conduct the first meeting. So we have discussed the rules and regulations relating to formation of COC and who can be there in the COC. Okay, the concept of related party, everything we have discussed in the previous classes. Okay, then the COC is going to conduct the first meeting. Okay, at the first meeting, they may continue with the IRP or they may appoint another RP, resolution professional. Okay, interim resolution professional to RP, or else interim resolution professional may not continue, other RP may be appointed. Okay, then subsequently you are going to prepare the information memorandum. Okay, then you are going to invite for the submission of resolution plan. Okay, so you are going to invite, then prospective resolution applicants, they are going to submit the resolution plan. Okay, we have discussed in detail about the resolution plan. Okay, expression of interest, everything we have discussed in the previous classes. Okay, so more or less, unless otherwise provided in the regulations, okay, the same rules and regulations will also be applicable even in case of fast track CRP. Then a resolution plan is examined and approved. Okay, then once there is approved by the COC, then you are going to place it, you are going to submit it to the NCLT for their approval. Then submission of plan to the NCLT. NCLT will not verify the commercial wisdom, as we have discussed in the previous classes. They are not going to verify the commercial wisdom. Okay, they are going to verify the procedural aspects, whether did you follow the procedure or not, they are going to verify. So once that is done, then NCLT is going to approve the resolution plan. Once the resolution plan is approved, okay, then it is a time for implementation. Okay, so if the resolution plan is not approved, then you may go for liquidation. Okay, so please remember whatever we have discussed till now, the detailed procedure, okay, this procedure must be completed within a period of 90 days. Okay, there is a possibility, okay, you can apply for extension, but it can never be more than 45 days. So that means maximum 90 plus 45. So it has to be completed within a period of 135 days. Okay, these are all the stages of fast track CRP. Okay, so as already we have discussed, time period for completion of fast track resolution process. So the process must be completed within a period of 90 days compulsorily. Okay, from the insolvency commencement date. We have discussed the meaning of insolvency commencement date already. Okay, then a one-time extension up to 45 days may be granted by the adjudicating authority, that is NCLT. Okay, but if you want to make an application for extension, okay, the resolution professional must be authorized. Okay, the requires approval by the 75% of the voting, 75% of voting shares in the committee of the creditors. So 75% of the votes must be casted in favor of the resolution, whereby they are authorizing the resolution professional to apply for the extension. Okay, so that is 45 days maximum. Then no further extension can be granted beyond 45 days. Okay, so maximum 135 days. Okay, you are expected to complete the process within a period of 135 days. This is mandatory. Then what happened if the fast track CRP is not completed within the stipulated time period? Okay, section 58 provides that the process of CRP and the provisions relating to offences and penalties under code shall apply to the fast track CRP as well. Okay, then to implement the provisions of CRP, that is fast track CRP, the board has, in exercise of its regulation powers, they have made separate rules and regulations. Okay, that is IBBA, fast track insolvency resolution process for corporate persons, regulations 2017. Okay, so you are expected to complete the resolution process within the framework of regulations. Okay, so if you fail to do that, what happens? Then you will go for liquidation of the company. Okay, so as already we have discussed even the previous classes also, if CRP, during the CRP process, if committee of the creditors fails to arrive at the resolution plan within the time limitation, then in such cases, the adjudicating authority will give the order for liquidation. Even in the case of fast track CRP also, if the committee of the creditors unable to arrive at the or approve one resolution plan, then in such cases, the NCLT will give the order for liquidation. Okay. Now let us look at the timelines in the fast track CRP. Okay. So already we have discussed the timelines in the case of regular CRP in another class. Okay. So the timelines discussed under regulation 40 of CRP regulations are different from these timelines. Okay. So first one, filing of application. So who is going to file the application? Financial creditor, operational creditor, or corporate debtor. Okay. Then admission within 14 days. Okay. From the date of receipt of application, within 14 days, you are expected to admit. Okay. So this is common for both CRP and fast track CRP also. Okay. Then public announcement. So IRP makes a public announcement inviting the claims and providing relevant info. So within 3 days. Okay. Then submission and verification. So from here actually the time framework will differ in case of fast track CRP. Okay. So creditor submit the claims which the IRP verifies. So it will happen within a period of within 10 days from the submission of the submission, within 10 days of the announcement. So within 10 days from the date of announcement you are expected to complete. Then constitution of committee of the creditors. So IRP will constitute the COC based on the verified claims within 7 days of the verification. Okay. Then first COC meeting will be conducted within 7 days of COC formation. Okay. Then COC confirms the RP as RP, that is IRP as RP, interim resolution professional as resolution professional, or else they can appoint another person as a resolution professional. Okay. So anything is possible. Then subsequent to that, the RP, because now RP will be there. Okay. Once the first meeting of COC is completed, resolution professional will be there. Okay. Then preparation of information memorandum. So the resolution professional, he will prepare the information memorandum with the COC in consultation with the COC. Then as soon as possible after RP is appointed. Then invitation of resolution plan. So typically it should happen within 21 days to 30 days. Okay, the RP invites the resolution plan and he is going to evaluate them. So invitation, evaluation must be completed within a period of 30 days. Okay. Then COC approval of resolution plan, section 30. So the plan must be approved at least 66%. Voting percentage is similar both in the case of CRP as well as this fast track CRP. So by the votes of 66% of the voting rights, the COC shall approve the resolution plan. Okay. So it has to be done within a period of 90 days. Okay. So if you observe regular CRP, for each and every activity, separate timelines are there, whereas if you observe fast track, okay, so 90 days, so within 90 days, so there is no prescribed exact time limitation within which the resolution plan must be approved. Okay, so within 90 days from the date of initiation of the CRP, within 90 days you are expected to complete. Okay, even there also 180 days you are expected to complete the COC. Okay, so compared with the timelines under the CRP, it is very simple. Okay. So submission of NCLT. So RP submits the approved plan to the NCLT for a final approval. So this has to be done before 90 days. Okay. So before 90 days, COC is expected to approve the plan. Then you are expected to submit the plan to the NCLT. Okay. Then NCLT may approve or they may reject. Okay. Plan is either approved or becomes binding. So if it is approved, it becomes binding. So as already we have discussed, once the resolution plan is approved, it is a it is a REM, in REM. It acts as a in REM. So what is this in REM? It is binding on all the shareholders, all the creditors, maybe financial creditors, operational creditors, and other stakeholders also. Okay. So once it is approved, it becomes binding. Or if it is rejected, then leading to liquidation. As already we have discussed, if the resolution plan is not approved, then in such cases, okay, so it may lead to liquidation. Okay. But NCLT is having, they don't have much discretionary powers while rejecting. Okay, so NCLT cannot verify the commercial wisdom as we have discussed in the previous classes. Okay, so only one possibility is that if the resolution plan is not approved by the COC, then in such cases NCLT will give the order for liquidation. Okay, so all these things must happen before 90 days or 135 days as the case may be. If the time is extended, 135 days, but in the normal circumstances 90 days. Okay. Then what is the role of resolution professional? Okay, So I can say more or less the role of resolution professional is similar both in CRP and fast track, except the case that he is expected to complete within 90 days. Whereas in case of regular CRP, it is double 90 plus 90. Okay, so 180 days he is expected to complete. That's the only difference. But smaller minor changes are there if you observe the regulations. But comparatively, more or less, the role of resolution professional is similar. Okay, an insolvency professional shall be eligible to be appointed as a resolution professional even for the fast track resolution process also. Okay, so what is the condition? If he and all partners and directors of the insolvency professional entity of which he is a partner or director are independent of the corporator. So that means he should be independent. That means if he is eligible to be appointed as an independent director to in any company, then he is also eligible to be appointed as a resolution professional. Simple logic. Okay, if any person is eligible to be appointed as a independent director, same person is also eligible to be appointed as a resolution professional, provided he is having the requisite qualifications. Okay, so then a person is considered to be independent. When a person is considered to be independent, okay, a person is considered to be independent of a corporator if he qualifies to be independent director. As already we have discussed, he qualified to be independent director under the Companies Act and are not a related party and have not been an employee, proprietor or partner of certain firms associated with the return. That means in the past 3 years, please remember. Okay, that means he is not expected to have any material pecuniary relationship with the company. Okay, then in such cases, okay, a person can act as a resolution professional. Then and resolution professional cannot be appointed as a resolution professional if they or their entity are under the restraint by the order of board. So if the board has given any order stating that so and so person is not eligible, then such entity cannot be appointed as a resolution professional. Okay, then they must make necessary disclosures during and after their appointment. Okay, so as already we have discussed, okay, whenever you are appointing the IRP, RP, resolution professional or interim resolution professional, you are expected to give the consent. Okay, and you are expected to give the resolution professional is expected to give the disclosures. So even in the case of fast track CRP also, he is expected to give the disclosures. Okay, and he is expected to make the necessary disclosures during and after their appointment and cannot continue if their entity or members represent other stakeholders in the same fast track process. Okay, if they are representing other stakeholders, then you cannot continue. Okay, let us discuss what we have discussed in this class. Okay, so today we have discussed what is fast track resolution process, what is the significance of fast track resolution process. So fast track resolution process helps the small scale industry or else small companies as defined under the Companies Act, and it helps the startup companies, and it helps the unlisted companies where the asset value is less than 1 crore rupees to complete the CRP process within the less time limitation, that is within 90 days they can complete. Okay, so this process is called as fast track resolution process. Then who is eligible? As already we have discussed, small companies and unlisted companies where the asset value is less than 1 crore rupees. Then startups are eligible for fast track resolution process. Then we have discussed about application for fast track resolution process. Who can make an application? Okay, so the fast track application, resolution process application can be made by, like, who can initiate the CRP regularly. Here also it can be made by either financial creditor, operational creditor or corporator as the case may be. Okay, then we have discussed the stages. Okay, the stages in the fast track resolution process more or less similar to the regular CRP process, but the condition is that this entire process must be completed within a period of 90 days. That's the only difference between regular CRP and fast track CRP. Okay, so there is a possibility you can extend the time limitation by 45 days. Then time framework we have discussed. Okay, so with this we have completed the concept of fast track resolution process, that is fast track CRP. Thank you.